welcome to the Personal Injury Law Show. This show talks about everything come to law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 30 years experience. With me tonight I've got Don Maffia, a partner in a law firm in transport accidents. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And the lovely, bubbly, effervescent Vivian Ryan, former lawyer and current director of Gravia Media. Good evening, Viv.
Hello, Tony. Don, good evening, viewers.
Viewers, tonight we've got a very important episode on transport accidents.
But Tony, before we get to that, what's in the news?
Viewers, we've got a lot of stories in the news. There's been so many sensational stories. Viv, the first one
It's not about me, I know.
No, it's VCAT throws out a planning permit involving a development because they haven't got car parks.
That's
Is
right.
that bizarre or what?
Well, I don't know. It's questionable because people are saying that that's actually more, these developers are more in touch with the community than ever before. Basically, keeping the prices more affordable by not having compulsory car parking within the units. However, you know, the residents around that might have a different point of view, given that without car parking in a new apartment block, it's going to then, you know, create problems with car parking on the street. So I don't know. They're trying to be more sustainable. This is a Brunswick apartment building, and I quite like the idea though.
But Don, not everyone wants a car. I mean,
Well,
a lot of the reason why people have bought in this area is because you've got a tram, you've got a train, you've got public transport right at your doorstep.
Well, it's targeted at those people who are more the green approach to it all, where they may not have a car. In fact, there was one lady who, because it's off the plan, of course, who purchased it and put a deposit saying, I don't own a car and I don't intend to own a car.
Correct.
But don't forget, it's not only a question of people that want cars. What about affordability? A lot of people can't afford to keep a car these days. I mean, there's insurance, there's registration, and a host of other things.
Well, I think it's just giving people a real alternative to, you know, inner city dwelling. So, yeah, I don't really understand why it was overturned, given that they were able to then employ whatever the zoning allowable rights, you know, for want of better expression. So,
I reckon we should get someone on this show to talk about this.
Well, Tony, it can save them up to, what, $30,000 without a car park.
Exactly,
That's not,
exactly.
It's a lot of money. So, look, I think there is those balancing interest in it. Obviously, the concern is, I mean, you can't prevent people from not having cars. So if they do have cars, like we've said, they'll be on the streets and take up all the street spots. So, look, there is a competing arguments there. I think it's a good idea, but at the same time, I understand it as well.
So with that, they've actually been able to then give their deposits back to people. Is that
Well,
right?
people have taken their deposits back. They've pulled out of the contracts with it. It's just insane. Anyway, we should get someone to come on and discuss that because it's going to have wide-ranging implications and repercussions.
Correct.
Anyway, Don, ground zero. Victorian drivers, senior copper, right, wants to introduce laws where 21 to 25-year-olds cannot drink at all.
No, I think it'd be further than that. I think it's across the board. He initially wants to do a zero blood alcohol content in all drivers, but of course that's going to be an outroar. So he's sort of suggesting 21 to 25, which seems to be the high risk group.
I guess my only concern, even whilst I support this move, given that it is that, you know, prone high trauma age group, the 18 to 25-year-olds, particularly in the male demographic. The only thing that I do question is that if people aren't taught how to drink and drive under the 0.050 legal limit, they probably do need to understand their own limitations. So whether it's a half a beer, one glass of wine, and then sort of being thrown into that environment after the age of 25, I don't know. I think there might be some room for massaging this law, even though I do support it.
I think we should be spending more money on education. Just teaching them about what not to do and what to look out for.
I agree, but we all know that alcohol can give you a false sense of security and really sort of mar the way that you make your own decisions when you've had a few drinks. So
what was that group that came on the show, Dom, that educate young people?
Roadwise.
Roadwise. I mean, that's what we should be doing.
There is all those initiatives.
Instead of
but I mean, to take this even further, I would actually, I know it would never get over the line, but I think males, this should be employed with 18 to 25 males because that is, you know, they are the ones that are most involved in these accidents.
Why don't we go ground zero on drug taking more to the point?
Well, that's the actual point. Since 2013, just quoting this article, drug driving has overtaken drunk driving.
Exactly. They should be testing for drug driving.
Well, then it brings us on to your next article about having these driver interlocks alcohol-related systems.
On all cars?
On all cars.
If that's outrageous.
Look, the thing is, I'm a mum, as we all know. I've got 2 children, and a lot of the time I'm running late. The last thing I want to be doing is getting into a car, blowing into something before I can actually turn the wheel, turn the key on to start the vehicle. So that would be my only thing, is the time efficiency component. However, yeah, there is a proposal for people to have to be able to blow into a system which would then give a 0 reading before people could actually start the car and then move on. I definitely think if you're going to do that, then you really need to have drug testing as part of the alcohol testing component on the alcohol locking.
Can I ask you this? Is this for everyone, Dom? Not just
that's a
people that have
proposal.
been convicted in the past.
Well, look, it's one of the road safety bodies who's saying maybe you should have alcohol interlock systems on every car.
Why don't we have drug interlock systems?
I'll tell you what, Tony, if you want
That's
to start,
probably,
if you want
I'm
to,
happier with that.
if that's going to go through, you should start your own business in making alcohol interlock systems. Imagine
We
every
should.
car being fitted with this.
Oh no,
I think that's
I'd be
taken
for
too
that.
far.
Viv. I'll be
100%.
honest.
I think,
Yeah,
as
yeah.
we all know, drugs and alcohol are kind of one in the same now as a problem within our society. So,
Drugs are worse.
Yeah.
Yeah. Well, I think it might be one way of curbing the drug problem, Dom.
Oh, may well, but
Because that's another safety measure.
yeah,
Anyway,
definitely.
we'll have to get the right people to discuss these issues. Viv, helmet laws on cyclists. This is up your alley.
well, yeah, I remember back in 1990 when the helmet laws were put in place in Victoria and they were made compulsory. And I remember thinking at the time, oh, who's actually going to do this? Because we were so liberal in the way that we rode our bikes. But since 1990, there's been a 16% decrease in injuries to the head. However, now there's some discussion around perhaps lifting the compulsory wearing of helmets because some people believe that it's detracting them from actually cycling, which, we have an obesity problem and that's what they're blaming is
Oh, no,
helmets.
Viv, I think the helmet's
It's a very interesting, interesting
That's right.
proposal.
This comes about from a parliamentary inquiry, federal parliament inquiry into, again, we'll talk about many states' laws, and one of the ones they've picked up is obviously helmets and compulsory wearing helmets. Now, I understand it's probably detract people from riding bicycles, but one of the complaints that they have is about not only that, but they complain about the discomfort from sweating. And my favourite is the ruined hairstyles. That's why they don't want to wear
That was
helmets.
actually one of my personal favourites.
No, what's more important?
Well, that's got to be safety and hairstyle. Well,
Yeah. Well, I found it interesting because one of the arguments was that a woman was saying that a pregnant lady can be told off for smoking during a pregnancy. However, then they then are forced to put a helmet on their child once they're on a bike. I kind of felt that argument was bizarre. Surely they would be wanting to look after their child who's on a bike. And look, we all know that if you've come off your bike, if you've got a helmet on, it has saved so many lives.
Of course it does.
I just look. I
Look,
think
there's
we
some
just
really topical
get on with it.
issues here. We can discuss them in the future. Before we go to the break, I just want to raise the issue of whistleblowers being protected in the sense that if they do come out and expose a large corporation, they do get paid for life, so they're not totally made to feel like lepers where they can't get another job. What do you think about that? Quickly, Viv?
Yeah. Look, I wonder what is a whistleblower? What's deemed a whistleblower, and what would they
Someone that
be?
exposes a large corporation to some of the things they're not doing right.
So what,
we
insider
wouldn't know
trading,
otherwise.
insider trading, wrongful stuff. But
Okay.
VW, all these sorts of things.
Yeah, I don't know about that one, to be perfectly honest. I think yes, you need to keep a watch on, the companies doing the right thing, but to be compensated for it.
Oh, I think we'll take it up another time, Viv. I'm really strongly for it.
Okay.
Viewers, we've got to go to a sponsors break. After the break, we're going to have Ahmed, Pervaz and Maffia discussing the update on transport accidents. Viewers, welcome back to the show. As I said before the break, we're going to give you an update on transport accidents. But before that, I'll introduce Ahmed Pervaz, a senior lawyer in a law firm. Good evening, Ahmed.
Hi, Tony. Hi, Don.
One of the things I want to talk about viewers, is there's been a reversal of criteria in relation to psychiatric injuries done.
Correct.
It's been a long time coming,
Yeah,
but it's welcome.
Yeah, so for the viewers, back in October 2013 in Victoria, the Victorian government back then introduced some changes to our transport accident laws, which means that they've increased or they raised the bar in terms of what you need to show in psychiatric injuries to get an entitlement
In other
to
words,
sue.
they really complicated the test in trying to get a serious
Correct.
injury for psychiatric injuries.
That's right. For a serious
Yep,
injury,
yep.
for the viewers, a serious injury is what allows you to recover your damages in Victoria for transport accidents. So they really raised the bar and made it
Almost
impossible.
impossible. Yeah.
Right? In fact, in the last 2 years, I haven't seen any applications go through with a new test for psychiatric injuries.
Well, the reason for that, Don, is you've got to get treatment for 3 years.
One of the tests was 3 years.
Ongoing, yeah.
Correct.
Ahmed,
yeah.
just curiously, you're familiar with this legislation.
Yes, I am.
I mean, to insist that someone in the public's got to go to a doctor for 3 years continuously to get treatment, it's almost begging a question, because the fact is they might not have any treatment available to them.
Exactly. And it comes to a point with certain plaintiffs where the treatment itself may not be helpful, they may not be gaining any long-term benefit from it. And for the law to then kind of have them in a position where they need to get that treatment to further
forces
their
it on.
claim,
Yeah.
it may not lead to anything.
Well, the good news, Tony, is the Labor government, when they came to power last year, it's been some time. They made an election promise to reverse or repeal these changes, and that's gone through Parliament as we speak.
And you'd be very happy, Don, because it means that a lot of people... let's be realistic. In society these days, there seems to be an escalation in the number of psychiatric injuries.
Oh, well, there
Is
is.
that a fair
So, yeah, look, it's a fair comment for lots of reasons. I mean, now with social media and TV and all what we see, it's an increase in that. But also awareness.
Yeah.
I mean, these days, people going through psychological effects that people are realising, well, there's a reason behind it and that how it affects them, where many years ago, Tony, they just brushed it off and...
Well, and the other thing too, Ahmed, is why should they discriminate between physical and psychiatric injuries?
Exactly.
I mean, psychiatric injuries, sometimes people never recover.
Yeah, and the law already has a more onerous test for psychiatric injuries compared to physical injuries, and then to add this upon that, the 3-year kind of regulation, it just seemed a bit over the top, and it's
Yeah, it's a bit too much.
Well, look, the intended effect was to reduce the number of claims, and it did that. And now we're back to, well, again, having a psychiatric injury doesn't mean you get an entitlement to sue in Victoria. You still have to show it's severe psychiatric injury.
Yeah.
This test just took it too far.
Yeah, I
And
think
that's
so.
gone back
I thought
to
the
square.
test was tough enough as it is.
Yeah. So it's good news, and well done to the government in Victoria for doing that and keeping to
Exactly.
their election promise.
In any event, they're probably saving money because people aren't going to doctors unnecessarily.
Yep.
Is that
Correct.
correct? Yeah.
Exactly.
All right, let's just quickly, before we get on to the first case, dodgy wills are coming in, imports don't.
Yeah.
A lot of cheap imports, they're charging you the same as any other wills,
Yeah.
but there's instances where you might hit a pothole and they just
Crack.
crack.
Break.
Yeah.
Yeah.
You know, I mean, so
It's
what do
gotta
you
be a
do?
lot more.
What do you do, Don?
I think if you've seen that article, there's about 500,000 wheels are imported from, or rims are imported from China. There's got to be a lot more regulation about it. I mean, having a wheel crack while you're driving to hit a pole, that is a dangerous situation.
Does that mean that when you go to get tyres renewed or mags or whatever, you've got to ask the dealer, where did they come from?
Yep, you want to probably know where they were supplied from, any quality control issues.
And warranties and guarantees, I guess.
Exactly.
Is that correct?
Yeah,
Don?
correct.
Yeah. All right. Anyway, let's talk about the first case. Soraya and Cornelius, a New South Wales decision of 2015. Who's going to give me the facts? Don, you want to give me the facts?
Yeah, this is a... Look, we've done one of these cases not long ago, Tony, on this show. Sort of similar circumstances where you have the plaintiff walking back from a party with a friend, dark street, sort of a country sort of road.
Yep.
And then there's a car comes along and hits
Heavily
the plaintiff.
intoxicated.
He was heavily intoxicated.
intoxicated,
Couldn't
yep.
find a taxi,
Yep.
so decides to walk. And as he's walking, there's a car that's come behind him, hits
Wow.
him,
Yep.
causes significant injuries. In fact, it is in New South Wales. They have different thresholds and different maximum of damages payable. He's reached the maximum. They all agreed that he is
That's
the
how
most
bad he
severely
is.
injured person regarding in the legislation.
Well, Ahmed, the most significant part of this case was the issue of liability.
Exactly.
Tell us a bit about that.
In this matter, it was found that the plaintiff, so the injured person in this matter, was found to be 40% negligent or contributory negligence in this matter, which substantially reduced the amount of damages he was to receive. So the maximum he would have received was approximately $2 million. Taking into account contributory negligence, he was then awarded $1.2 million, which is a significant discount.
Don, what are the main reasons why the court found it was negligence and then reduced it by 40%?
Well, there was a number of things they're looking at. Firstly, the issue was whether or not the driver or defendant driver had his headlights. So the plaintiff was walking with traffic, not towards traffic. So he's walking on the eastern side in a westerly direction. The driver's coming behind. So first question was whether or not they had their lights on. And I think the court
there's
accepted.
also a big issue about whether they had the high beams on.
Well, first
They
of
said
all,
maybe they should have had the high beams.
first of all, was their
Yeah.
headlights on? And the
Yep.
court found, because of the witnesses saying that, look, there were headlights on, accepted there was headlights on. Then the next question was whether or not he should have had high beams on,
Yep.
because it was a dark street.
Well, there's no light. There was no street lights.
No, it was a dark road.
Yep, yep.
And the court found in that instance to say, well, look, listen, in those requirements, it didn't require to have a high beam on because there was an oncoming vehicle in close proximity. It wasn't a necessity to have the high beams on. So by failing to have high beams on, didn't necessarily mean that he's breached his duty of care owed to the plaintiff.
Okay. One of the other things they looked at was speed. There was a lot of conjecture about how fast the defendant was going.
Yeah, and there was expert evidence brought in to discuss this issue of the speed that the defendant was going, and it was finally kind of agreed that the speed he was travelling at was about 45 kilometres an hour, plus minus 5 kilometres an hour. So that, in essence, became a non-issue in this matter. But it then also kind of played into the issue of the defendant's alcohol level and how that may have affected their judgment and their reasoning and their capabilities of driving.
Don, I thought the plaintiff was a bit unlucky in this case because there doesn't appear to have been a proper footpath to walk on.
No, but he was walking on a gravel verge of the road, quite close to the road. And the point was that, well, first of all, the driver was also found to be partially driving on a gravel verge. So he was partially off the road, or she was partially off the road. But the point was, because the plaintiff was intoxicated, and when before the car hit him, he actually stepped to the right rather than to the left.
Yeah, because he was startled.
Well, he was.
Yeah.
And that's where the expert evidence came in to say, well, look, listen, when your perception or your judgment at the time when you're affected by alcohol is very poor. And obviously that judgment that he's made. But also, walking, and this is a thing not many people realise, walking with your back towards oncoming traffic, the judge referred to that as a death wish. Because that's what he had an opportunity to see a car coming. If he was walking the other way, maybe he could have avoided it.
Don, the plaintiff lost 40% of his damages based on contributory negligence, right? I would have thought that in circumstances where it's a road that's reasonably foreseeable that people are going to walk on it, right? Trying to get home in circumstances where they can't get a taxi or a ride home, that they should have sued the local council because there wasn't a road made available.
I think, but then, Tony, you bring in all to those considerations about whether or not councils are liable, having resources, defences to that. I mean, it's near, not impossible, but having a claim against council in these circumstances will be, I would say, quite important.
You could have done some research in terms of how many people walk on that road, how many accidents have been on that road. There's a lot of issues. I would have thought that this case would have been very risky on the issue of liability and contrib, and that, the fact that there wasn't a proper footpath contributed heavily to the accident.
Yeah, look, it's something that could have been taken into account. Maybe a bit of information could be sought about the circumstances of the road and why there wasn't a footpath there. But in essence, I think it came down to the driver itself and the pedestrian both being affected by alcohol, the circumstances of the accident as a whole. And it kind of follows on from the trend that we may have spoken about a few shows ago about the pedestrians being found contributory negligent in these matters.
It's changing again.
Exactly.
Viewers, we've got to go to a sponsors break. After the break, we'll take up this discussion of transport accidents and the update. Viewers, welcome back to the show. We've been giving an update on some transport accident cases and law. Don, you wanted to finish up in that last case. What do you want to say?
Well, look, Tony, with this pedestrian case, we spoke about many pedestrian cases on this show, Question is whether or not the plaintiff was there to be seen.
Yes.
And I think in this case, the plaintiff was, and that's why, look, they did find 40% against the plaintiff.
I thought that was
Sorry,
harsh.
60% against the plaintiff. Well, no, reduced
No,
by
it's 40,
40%.
yeah.
60% against the driver, on the basis that, look, he's there, they're pedestrians, and any experienced or even experienced driver, just keeping a proper lookout, should have seen him.
And Ahmed, there seems to be a shift away from a pedestrian being protected at law these days. Once upon a time, there was that decision, Western Australian High Court, mind you, where, you know, they looked after the pedestrians. Now the courts are saying, look after yourselves. They're starting to take that approach, aren't they?
And I think more so in circumstances we've seen where the pedestrian may be affected by drugs, where they may be affected by alcohol. We've seen a shift in that trend, which was going on for many years, and I think pedestrians do have to be more wary now.
More vigilant.
Exactly.
Yes. Okay. All right, Glenn and Sullivan, you want to give us the facts, please?
Yep,
Ahmed,
yep.
this is a New South Wales decision of this year.
Yes, New South Wales Court of Appeal decision. The plaintiff or the injured person in this matter was a traffic controller who was struck on her hand and forearm by a vehicle. The vehicle was found to be at fault. There was no particular issue with that. The issue in this matter, like a lot of matters that we may see now, is a matter of credit. So there was surveillance material of her.
Yep.
And it was essentially found that the surveillance painted a very different picture of her disability and incapacity when compared to what may have been reported by herself or in the medical reports. And plaintiffs need to be very wary of this at the moment. There is much case law at the moment on this topic, and judges are taking it into account, and they should reason through the material. The medical professionals involved in the case should have an opportunity to also review the surveillance material and comment on it. Now, the surveillance material is now kind of extended beyond video to Facebook material, Twitter, social media.
Snapchat. I mean,
Exactly.
Look at Carlisle. I mean, look what it's done.
Yeah,
He's
exactly.
Yeah, yeah.
But in his case, Tony, she injured her left hand. There's no fractures or anything. What it was, it ended up being a condition called complex regional pain syndrome. Now, there's a lot of medical, and again, we're not doctors, but interpretation of what that is. Some say it's physical, others say it could be psychological.
Yeah.
In this case, she presented as someone who could not use her left arm. And,
Yeah.
and look, I've seen many people with this complex regional pain syndrome causes debilitating symptoms. And she presented as someone who kept her arm very close to her, didn't move it. But
Yep.
then, of course, on surveillance, she was moving very freely with her left arm. And the judge there actually said, well, look, okay, I accept the accident happened in 2009. I accept that you were suffering some symptoms, but up until October 2011, you stopped suffering from those symptoms. And that was in light of what the surveillance material found, but also she had other credit history of not giving doctors full histories or full and proper histories.
Well, Don, that raises the issue. In a lot of instances, people think they can be smart, they can hide stuff. In this day and age, with technology, surveillance, your Facebooks, your Snapchats, and just doctors' clinical notes, Don,
Yep.
there's not much you can hide because realistically, the defendants get a printout from Medibank, whatever it's called,
yeah,
and they say,
Health Insurance
okay,
Commission.
you've seen all these doctors over the last 30 years, give us the notes of Dr. So-and-so, 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 and so-and-so, and so-and-so. So you think you'd be smart as an injured person, go to a different doctor for this accident, but it's going to come up. You can't hide anything. So isn't the real issue that people should be frank with their doctors
Correct.
and with whoever they speak to in relation to their injuries, correct?
Correct. I think when she's made an inconsistent statement to a doctor, like in this case, she's presented as a very debilitated person in terms of the injuries, and then on film it's completely different. The damage is done, so you might as well be upfront, deal with those issues. And Tony, we always say, look, surveillance is not worth anything, or any of this surveillance material.
If you're frank.
Exactly,
Yeah.
or unless they catch you doing something you said you can't do.
And the thing is, you shouldn't be, Ahmed, you shouldn't be using the words, I can't do this, can't do that. You
No.
should really say, I have difficulty doing this.
Exactly.
I might try to have a game of golf, but then I had problems. You can't say, I haven't played golf again, and then they catch a swinging, you know.
Exactly. And it's important to be accurate to your doctors or to the person you're reporting these injuries to. The defendants have become more savvy over the years. There's a lot more material for them to kind of cross-reference. So it could be post on social media, cross-reference with the notes of the doctor, cross-reference with any insurance doctors you may have seen at the time. So it is very important for them to be accurate and upfront with their complaints.
and consistent. Isn't that right, Don? Also, look, you run the Transport Accident Department at Carbone. You'd like to see these people very early in a piece, wouldn't you, Don?
Well, that's right. Look, give them early in the piece because we'll also obviously advise them through the claim as well. But also tell them, look, it's okay to do things. There's nothing wrong with doing something. What is wrong is if you say you can't do something, then you're caught doing it.
Yep. And Ahmed, you want to focus them on what's your injury? What is it you say you can and can't do, or have difficulties doing? You've got to talk about consistency. You've got to talk about treatment, medication, and you can't, rock up to the lawyers and doctors totally disabled, and then when you're out in the street, you behave like a 2-bob watch, can you, Don?
That's right.
Yeah. Anyway, just quickly, we've got this case of Transport Accident Commissioner Campbell, Victorian Supreme Court of Appeal decision of this year. Just quickly, can you give me the facts, Ahmed?
This is a matter where it was appealed from the County Court of Victoria. The Transport Accident Commission of Victoria is the appellant in this matter, so they've appealed the matter. An accident where the plaintiff, at first instance, was struck by a vehicle that had gone through a red light, so there's no issue as to whose fault the accident was. But there was an issue again in this matter as to the credit of the plaintiff, being not only, I think they had surveillance of her over 13 days, but also the employment history or the details of her employment history that she told the doctors of, as well as many other instances of inconsistency in her story.
And Don, what happened in the Court of Appeal? Well, she won in the first instance. In the Court of Appeal?
Yeah, so before a judge, and in Victoria is seeking permission to sue. So the whole trial just to do with seeking permission to sue. And to do that, you must have a serious injury, which you're referring to. And the point was that the judge was found not to have dealt with the surveillance material and the failure to disclose a history and put enough emphasis on that. When I put enough emphasis, say how he dealt with it, because it was very inconsistent with what evidence she was giving.
It was inadequate reasons, really.
Correct.
That's why it's gone back to trial.
So the Court of Appeal just said, well, you got to send it back downstairs or down to the county court and get it retried before a different judge to deal with these issues.
And get adequate reasons as to your pathway of reasoning to get a decision.
Show why, look, if a defendant, or in any case, if someone loses, you've got to know why you've lost. So the fact that he didn't deal with those issues, or the judge didn't deal with those issues, explain the extent of the surveillance, because it was so inconsistent with the way the plaintiff presented how he dealt with it.
Anyway, viewers, we've come to the end of the show. Don, thanks for coming on board.
Thanks, Tony.
Ahmed, thanks for coming on board.
Thanks, Tony.
Viewers, thanks for watching. Stay tuned for future episodes. Go to our past episodes on YouTube. Go to our social media platforms, and always remember to stay safe.